So welcome everyone. My name's Andrew. I am the Fort Bend County Law Librarian and the manager of the Fort Bend County Law Library. And so welcome to another edition of our attorney lecture series. I believe this is like our 10th one now. Jonathan, is that about right?
Yeah, that's about right.
So this year we're focusing more on attorneys. Last year we focused a lot on pro se's and what they might need to know dealing with the courts here in Fort Bend County and just general basic information. And this year we decided we would focus a little more on attorneys, especially younger attorneys. Maybe you're just out of law school or you need a refresher on something. And so this time we are going to be talking about discovery. So I'm going to let Jonathan here introduce our speaker and we'll get started.
All right. Thank you, Andrew, and thank you, everybody, for attending. Our speaker is Andrea Barr. She's a native Texan and a longtime resident of Fort Bend County. She's a graduate of the University of Houston for both her undergraduate and law degrees. She practices in civil litigation, focusing primarily on fiduciary litigation, probate, and trust litigation. And she's an associate at Ford Bergner LLP in Houston. She is a frequent visitor to the law library. I got to know her because we worked together for a while, but she's also comes to the law library. And her last trial, or not her last trial, but one of her more recent trials was here in Fort Bend County in the county courts at law, involved in a fiduciary litigation. And so we're honored to have her here as part of our attorney lecture series, and she's going to talk to us today about discovery issues. Obviously, there were some changes that came into play on January 1st. So she'll probably touch on those and some other information. So take it away, Andrea.
Sure. Okay, so I'm going to talk about some of the amendments to the rules that just recently went into effect in January, as well as the different ways to draft discovery responses and discovery requests. And I've included in my materials a lot of a lot. So hopefully nobody actually printed what was sent because it would have killed a lot of trees. I sent a lot of things just for electronic use. I'm going to start with, and on my slide covers it. So one of the big changes with the new amendments of the Texas Rules of Civil Procedure is it's mirroring the federal rules of civil procedure. So now, instead of having requests for disclosures, we have required initial disclosures. And what this means is, for people who've been practicing a while, is originally, if you're a plaintiff, you could send your petition with discovery responses, and you might get lucky. And if the person didn't answer they appeared in a lawsuit and then didn't answer the discovery, or failed to give their attorney that they hired their discovery requests that were attached to the petition, you might possibly be able to get them waiving their objections to the discovery request that you sent with the petition. Well, that's now out for any lawsuits that have been filed, any cases that have been filed on or after January 1st of this year. So in my appendix, I included the Texas Rules of Civil Procedure with the red font showing the amendments, the 2021 amendments. And then I also have a second set of the rules that how they were previously, because for cases that were filed before January 1st of 2021, the old rules would apply. And so if your case was filed before January, you could serve a request for disclosure, or you might have to respond to a request for disclosures. So I included that. And I think one of the big things about initial disclosures is that the difference between it and requests for disclosures is that you have to produce records almost immediately after you start a case. Like it's 30 days after the answer is due when the initial disclosures are required to be produced by the party. So, and that includes if it's a personal injury case, you have to produce the medical records you have, things like that. And so it's going to change most attorneys' practice, because now when you first meet with your client on a case, you're asking them for documents. I mean, I already do that, but some people don't. But you should ask them for everything. So when you first meet with the client and you're doing a litigation case, you should probably now, because of the initial disclosure, say, I need all your documents. I need all your text messages. I need your emails. I need your social media posts. I need any documents related to this case. Even if you think it's just peripherally related, I need it. That way you have the documents and you can go through them early on before your initial disclosures are due, and you can pick out what's privileged, what's irrelevant, what's not responsive, and also you can have it for discovery after that. So when you first start to draft discovery requests, usually you're probably overwhelmed, at least I am, because I don't really like discovery. It's kind of the bane of my existence. Can't we just have an agreement to give each other all the information? But instead, usually it's like pulling teeth. So you have to carefully draft your requests. And part of that process is you go to review the petition, the live pleading in the case for the discovery level. And the reason I say this is because depending if it's 1, 2, or 3, you have limitations. So if under 1, for example, level 1, you are limited to 15 requests for production. You're limited to 15 requests for interrogatories. And you're limited to, in level 2, you're limited to 25 interrogatories. Level 3 is a totally different matter. So level 3 is usually people pleaded if they don't want to have to pick, and you want the court to enter a docket control order to control how the discovery is done. What I see happen a lot is somebody pleads level 3 and then no one actually asks for a docket control order. And so you have to, when that happens, the default is you go to 2. So level 2 is the default. And so if someone does plead for level 3 and they haven't gotten a docket control order and you're trying to see what the limits are, you go to the default, which is 2. Or you ask the court for a docket control order if they haven't, and you put the limitations in there. Second step of you, and the reason I say you do this is because you don't want to go and draft 20 ROGs for something that's under a level 1 and then look at the limitations. And if you accidentally send something out that's past the limit, the other side isn't going to respond. If they're worth a grain of salt, they're going to look at the request, and when they hit that 15 discrete interrogatory, everything after that, they're going to say you've exceeded your permissible limit of interrogatory, and you're not going to get any responses. So you just spent a lot of hours drafting requests that nobody's going to respond to. The next step is to look at the docket control order, or depending on where you are, they call it a scheduling order or a trial order. That's why I included that, because it depends on what county you're in. So you need to confirm that you can send the discovery requests out, because once the discovery period's open, which is different now. Before, you filed a case and it's like, discovery's open now, time to do business. Now under these new rules, you are not allowed to do discovery until after the deadline of the initial required disclosures are due. And after, the word says, the rule says after. And so there's been some discussions on social media on, well, can I serve it on the day the initial disclosures are due? Well, the rule says after. So I wouldn't play with that. I would just do it the day after, because it says after. And I don't want to get into an argument about it. You can also reach out to opposing counsel if they're represented or the pro se party, and see if you can get them to enter a Rule 11 agreement about discovery, if it can open up sooner, or if you can change the limits. You can do that. Most of the discovery limitations can be changed by Rule 11 agreement. The only one that you can't really change without court help is an expert designation under a docket control order. Most of the time, the court requires that you bless that. But you go and look at the docket control order. You look and you're like, okay, the discovery period expires X. Say it's 60 days out. Well, that's great, because that means you can draft your discovery and get it out. and then the opposing party has 30 days to respond. Now, the reason I say 60 days is probably more ideal than 30. If you look at your DCO and you have only 30 days, that means you have to get the request out today. And if they don't fully respond, you're not going to really have time to file a motion to compel and have that heard before the discovery period expires. So you'll be in the situation where not only are you going to have to file a motion to compel, but you're going to have to file a motion with the court and ask for more time for discovery. So I try to, just as a practice note, I try to send my discovery 60, 90 days out, or as soon as I get on the case and I'm able to kind of get an idea of what the contentions are and everybody's filed an answer, then I send my discovery. And you might send, 3 or 4 sets depending on what information you get from the first request you sent. You also review the live pleadings, and I'd say the latest petitioner answer, but you look at the live pleadings, and that's how I determine. I kind of make an outline on my notebook of what the defenses or the claims are and the contention facts, and then that's what I use to draft my requests, because those are the issues you're dealing with. Also, you want to look at the live pleadings to get their names right. Everybody's names, the parties and counsel. I've listed out the different kinds of requests, discovery requests that we have, depending, and I put in paren just the uses for them. So I usually, a lot of the levels of the discovery levels, have unlimited requests for production for some of them. And I like to use more requests for production than interrogatories, because interrogatories, I feel, are usually you're asking a question and it's going to be a self-serving answer. So unless you're doing the interrogatory to find out information you need, like, for example, financial institutions, dates something occurred, people's names, phone numbers, things like that. That's what I use interrogatories for. My request for production, I rely on them heavily in my cases, because the document says what it says. So when they produce the document, you look at it and it's like, okay, well, the bank statement says they took 35,000, like it's black letter, there's 35,000 going out of the account, versus you asking an interrogatory and saying, identify all the withdrawals from this account. Well, they don't have to do that. And actually, in discovery, if I'm the person responding to those requests, I just say, see the documents. I see documents Bates labeled as whatever, and I point them to the bank statements where the money's coming out. So requests for disclosures were used in cases that were filed for January 2021. And it's basically just general contentions. You go through, it's the general information that somebody likely needs to go forward with discovery, because the other side's identifying their factual, general factual and legal bases. They're also identifying the witnesses. So that's another thing that you're going to review. If you have a case that it had an RFD response in it, and you're just now looking at doing discovery requests, that's another thing you can look at, is look at the request for disclosures. If I'm doing a personal injury case, the other side should, depending on who it is, if I'm the defendant and I'm against the plaintiff who's a personal injury plaintiff, they're going to identify their doctors, or they should, their doctors in the request for disclosures responses. They should also identify if somebody was in the car. If it was a car wreck and they had a passenger in the car, that person would be a fact witness. The sad thing, though, is they might not. So you can't heavily rely on discovery responses being complete. If you think that something is missing, follow up with it. If the RFDs, you think they're not complete, you can follow up. That's what an interrogatory would be. You can do specific legal and factual contentions. So, for example, I do probate litigation all the time. So somebody says that the decedent, that's the dead person, was unduly influenced to execute their will. So I might ask, please describe how you contend the decedent was unduly influenced. Include the person's, the incapacitation, control. There might be factors I'd list out. Or if I'm talking about a will signing and I know they're saying the person, either it was a forgery or they were unlikely to influence, I'm going to say, please describe the circumstances surrounding the will, May 10th, 2019 will execution, including persons present, witnesses, time of day, location, things like that. So that might be a specific interrogatory that I might send. But you're limited on how the interrogatories can be done, which is, I say, you can't marshal all available proof. So I specifically, you have to be careful how you do it. You can't be like, give me all your papers about your defensive waiver, or please describe all your bases for your defensive waiver. It has to be specific, and you have to limit it. Request for admissions, I use sometimes when it's an undisputed fact, or to prove up documents. Like I'll attach a document and I'll say, please look at Exhibit A, and identify it as a true and correct, or admit that it's true and correct. Sorry. I also, there's a request for entry onto property example in the packet. Those are used a lot in construction cases. They're also used in insurance cases where there's been a fire. Request for inspection of property is when, say, there was a trucking wreck and someone wanted to look at the governor in the truck to see. You might do a request for inspection of that to go see the governor, because it's usually either in a tow truck lot, or it's a certain location the insurance company uses to take wrecked out vehicles. The last category of written discovery is deposition on written questions. I use those when I send a subpoena or ask for records. I usually don't use them for anything else but to prove up the records I've requested, because it's like taking an oral deposition. So you can go to an oral deposition and people are put on the spot, and they might not give the responses they typically would if they have time to respond to written discovery. So I prefer to do oral depositions, not written, because if you send them a written one, the person answering them is likely not writing those answers. The answers are written by their attorney. So if you're going to use deposition on written questions regarding disputed facts or legal issues, I would do it sparingly, because you're not getting it from the witness. Next, when writing discovery, you want to have instructions and definitions, and I've included the rule on my slide in my packet where you can look at the definitions under the Texas Rules of Civil Procedure. I've also included examples of some of my instructions and definitions. I have a very specific definition for accounts and account documents because of what I do. It's something that comes up all the time, and my definition is such that I want all the records. I want all the financial records out there. CD, savings, checking, I don't care what it is. If it's a financial record of that person or specific issue, I want it. So I included that in the packet. Now these definitions are purely subjective. Everybody has their own preferences on how things are defined. And so I even change my definitions. I look at them from time to time, and I change my own instructions and definitions pretty regularly, because it's like I'll read a case or somebody will object to them, and it's like they actually made a good point. I need to fix that. I need to make it better. I need to clean it up. So O'Connor's has a pretty good set that if you're using forms, O'Connor's and Gersanio have good sets for instructions and definitions. I always add the definitions for the parties or you. And since I do fiduciary stuff, I usually have to add like different capacities, because it's not just individually. And if you're dealing with a business, that's a totally different animal. So if you're looking to serve a business discovery and they're not a party in the case, you probably should check the Secretary of State, make sure you have the proper entity name, because especially with financial institutions, they will find any way to not give you the records. So if you don't have your subpoena to the right entity or the right registered agent, it dies right there. You spend all this money, you get them served, and then they're like, I got you, wrong entity. So check the Secretary of State website. If you get unofficial copies, I think the search is like $1, and then getting the registered agent information is like $2 or $3. And at our firm, we just charge it to the client that it's for. We expense that to the client, but it depends on how you do your business. But serving on the proper party and getting their name right is very important. Next step, writing discovery. This is like, I was taught this as a law student, and it really works. Read it out loud. So if you read your discovery request or response out loud and it doesn't make sense, or you have to stop and catch a breath, it's too long. It's too long. If it doesn't make sense, you need to rewrite it. The reason why is when, as a litigator, if you do make it to trial, you might be using these discovery requests and the jury might have to read them. And you want a layperson to be able to understand what was asked and what the answer was. And if, as a lawyer, even you confused, the jury's going to be confused. And if you're having to take breaths, it's like, okay, this person's got excuses. This is all legalese. I don't know what this is. And I'm not necessarily talking about your objections to discovery responses, because that's a different beast that I'm going to get into later. But for the requests themselves and then the response itself, not the objection, you want it to be written in such a way that it's like having a conversation. Like, for example, just to give an example of that, is someone asks you, please describe what happened at the intersection at Washington, near TC Jester, or, the Wild West Bar. I don't know. At this time. Well, what happened was a wreck, right? So your client was the injured person because somebody ran a red light. You could say, you go through this whole lengthy, like, setting up your case, or you could say, defendant ran red light and T-boned my car. I was hospitalized. And leave it at that. You don't necessarily have to, as an attorney, make it a perfect response such that you could use it in a summary judgment and it's literally all your elements. You sometimes want to write your response such that it's in your client's words, so it's credible. It meets the requirements for your proof for your case, and it is somewhat self-serving because usually discovery responses are. And you can read it to a jury and they'll be like, oh man, they ran a red light, got T-boned, and they were hurt. The next rule that I cover, and in my materials, I include a chart of all the different rules related to discovery. I include the old rules, I include the new rules. I also include some of the rules of evidence and some of rules related to privilege. I'm not going to go over that chart. I just included it because I use that for my use. It's a quick reference, so you can pull up the rules in the PDF I sent. So if you're having an idea about a certain rule, you can look at the chart, Control F, the PDF of the rules, and pull up that rule when you're getting ready to work on discovery. So one of the rules is you have to serve any discovery request, disclosure, notice, response, and objection on the party or person must be served on all parties of record. And as an attorney, we're lucky that, and some pro se people are sophisticated enough to do this, but as an attorney, I'm lucky enough, and I'm sure some of you guys are, and the library has it as well. The Fort Bend actually has it in the clerk's office. I don't know if they do because of COVID anymore, but they used to have computers in the lobby of the clerk's office where you could go and file things and serve things and use the electronic service. And so I e-serve all my discovery, responses, requests, notices, anything like that. I e-serve it through Texas e-file or ProDoc so that I can actually show the person was served electronically. And you can go and look at your confirmation on through Texas e-file, and I can pull it up and I can actually see when the person opened it. So I use that if I'm going to be doing a motion to compel, or if we're having some discovery disputes, if they say they didn't receive it, I can actually pull it up. And it's also a good way to see if you did their email address wrong, because if they never opened it and then the other side's like, we didn't get it. And then, I'm sorry for the barking. They didn't get it. And you can go and look at the service confirmation for the TXT file and see what went wrong. And you can't necessarily do that if you're doing it from your server and you play an email of having proof that it was received. Non-party discovery. So some discovery requests and some discovery materials are filed. Not party discovery, but non-party discovery is filed. So for example, I have a subpoena packet and the appendix. I file the whole subpoena packet. So I file the whole thing in the court record. And if you're checking a box, you can uncheck a box if you have to choose what you're doing. When you're filing that, I choose notice. I don't check subpoena because it's just you filing the non-party discovery in the court record, which is required. There may be some confusion about that. If anybody has questions, I've included my contact information in the materials. Sometimes the courts can require discovery to be filed in the docket control order, but most of the time they don't want discovery filed. They don't want discovery certificates filed. Some people still do that, but there's a Texas Supreme Court comment on that. They got rid of it for a reason. It's because it was flooding the docket, and there's a certificate of written discoveries are still being filed. Some people still do it, but some of the courts frown upon it, and it's not required. Regarding discovery, objections, and responses. So for requests for disclosures or initial disclosures, there are no objections generally, except for protective orders. So, and in that instance, it's under where you're having to disclose the person's name, address, and phone number. There might be a basis, and there is case law on this, there might be a basis to object to disclosing a person's name, address, and email address under the request for disclosure responses or initial disclosures, because they're under a protective order and they don't want the person who's under the protective order to know where they are. Or there's a family violence situation and they actually shouldn't have to. In instances where under initial disclosures where it just doesn't apply, for example, they ask for personal injury, medical records, and the case doesn't even relate to personal injuries, breach of contract, you just say not applicable. You don't have to object or say this doesn't, you don't have to object to say this doesn't apply here. You can just say not applicable. And most attorneys, at least I do, I accept it. I'm like, yeah, you're right. I don't know. I don't need a response to that. It doesn't apply here. For requests for production, there's different ways of responding. I actually will cover that on the next slide because I have a particular way I do it, but there are many different ways you can handle how to respond to requests for production. For interrogatories, you need to make sure that your client serves a verification, or now during COVID times, an unsworn declaration saying that the responses are true and correct. I do this even if we respond very little and it's mostly objections because they were poorly written interrogatories. I still make them do the verification because as long as there's some factual response at all, they should verify it. And it should be limited to their personal knowledge and not something they heard from someone else. You, at times, if you're somebody that is up against the deadline and you don't have your verification, but you have your interrogatory responses, I've seen it probably 9 out of 10 times happen where opposing counsel serves the interrogatories. I don't have my verification and they supplement it later. If you see it coming in, what I do is I don't give them a hard time. I just shoot them an email and say, hey, I didn't get the verification. Hopefully we get that soon. And then I calendar it on my calendar to remind myself to follow up back with them to make sure I get that verification. Because when you go to trial or you're doing their deposition later, you want to be able, this is your sworn statement. These are your sworn responses. And if you don't have that verification, you can't say that. So if you see it coming in without that, calendar it. I try to give opposing counsel some deference and cooperation. I'm not giving a hard time if I don't get it when it's due, because I've been there with a client. You send it to the client days ago and you still don't have your verification for the interrogatories, and it's like, well, it's deadline. I gotta serve these responses. You let the client know, like, I really need that verification. I'm serving your responses. We're gonna have to supplement with that, and that's what you do. For requests for entry on a property, or excuse me, for requests for admissions, for example, if it's a compound question, and for example, you hit Denise's car because you ran the red light. Admit you hit Denise's car because you ran the red light. Well, it's true that the defendant hit Denise's car, but the defendant didn't run the red light. So that's when it's on the drafter, because you shouldn't have done a compound request for admissions, but you have to respond. And so it's like, admit in part, deny in part, and then you'll have to explain why. The rules don't necessarily cover that very well, just the black letter of the Texas Rules of Civil Procedure. But in practice, and you can object to it as being a compound request such that they're not able to admit or deny. You can do that, and then you can respond. I typically just respond, admit in part, deny in part, explain it. I don't necessarily, because I'm responding and waiving that objection. It's kind of, if you go to the judge, they're going to look at you and be like, really? You answered it. For requests for entry onto property, you have to identify in your request who's coming, and if, say it's a construction site, like I'm going to somebody's house because they didn't do really good repairs after Winter Storm Uri, and so we're doing an inspection to see how bad they did. And I'm going in there and we're taking samples of sheetrock to see if there's moisture still there, if they actually teared it up and there's mold in the walls. Well, we're going to actually have to poke a hole in the wall. You actually have to say that in the request. And so when you respond or object to it, if they didn't do that, if they did say that they were going to destroy the property and poke a hole in the wall, you can object and say, we're not doing that. We don't want any destructive methods of inspection. You can come and take pictures. You can do moisture readings with an infrared, but you're not cutting any holes in the wall when you come there. And so that might be an issue you have to go to court and get the court to rule on, or maybe you'll be able to work it out. Maybe they'll agree to that. For deposition on written questions, you can object to timing of the request. If they gave you too short, unreasonable time to respond, you can object, of course, for if it's a non-party subpoena range. There's so many different ways that you can object to it, and different bases depending on what you get. But like I said, I only use deposition and written questions usually for proof up of documents in place of a business record affidavit. So for drafting discovery objections, some might say I do it like a motion or a brief. Under the rules, we're required to have a good faith, factual and legal basis for the objection at the time the objection is made. And we have to comply to the extent we didn't refuse to comply. So that's why I said, like with the RFAs, if it's a compound RFA, I might not necessarily object, because I am going to respond, admit in part, deny in part, and explain why. For my objections, I typically have some law behind it. So if I'm going to object to production of a tax return, I actually have case law on that, because that's something that's asked for pretty often in the kind of work I do, and depending on what type of dispute, it might be relevant and at issue, or it might not. And so I work in guardianships, for example, and I'm in a guardianship right now, and the other side asked for the tax returns of the ward, and I didn't feel comfortable giving it to the opposing side. There's a temporary guardian who has been appointed by the court. So what I did is I objected to the tax returns. I gave my case law, and then I actually said in my responses, and this is an unusual circumstance, but it's a way to compromise, is I let them know I produced it to the guardian. I don't think they're entitled to it, but the guardian's entitled to it, and they're a party to the litigation. So when I served my discovery, I had to serve some Bates label to the party who was asking for all this, and then I served all of it to the guardian. And it was my way of compromising, because how am I going to explain, if I have to go to the court, why the guardian isn't entitled to the tax returns of the ward, the guardian of the estate? It would be a hard battle to even, I don't want to go there. So I didn't think the other side was entitled to it. So, because tax returns are very sensitive, and the courts have ruled on that repeatedly. So I compromised. So if you can, in a way, compromise a good faith basis with your factual and legal basis for your objections and your response, not only, I think it's just a better way to practice, because judges get frustrated when we go there and we're having a discovery dispute. And usually the first question when you go to a discovery hearing is, have you guys conferred? And then they'll make you go in one of those back rooms and confer. And so confer, call them, email them. You're going to have to do a certificate of conference on your motion to compel, or if you're responding to a motion to compel, you're going to have to explain if you guys have talked. And don't just email. The courts want you to call. So I would recommend to call at least once. If the person is offensive or ridiculous on the other side, at least try once. And if they're being unreasonable, follow up with email and written correspondence, and have your conference letter. I have specific letters for when I have to confer about discovery, and I have a lot of them because I use them as my exhibits in my motion. Also, don't be that person. I have it in the practice note. Global objections or boilerplate objections are discouraged or prohibited. Don't go through and copy and paste every objection to every request, just like down the line, and take that position. Good luck. Like, take me to court. That's when you'll get some papers or some information, because if the judge gets really frustrated, and you're going to have to produce or give the information. If they're poorly written, that's one thing. And if it's poorly written, before the deadline comes, I would just call opposing counsel and talk to them. Like, can you rewrite this? Can we do a Rule 11 to limit and reword these requests? And I've done that before, where we've had a Rule 11 agreement. It was just a poorly written request. And I called them. I said, well, this is what I think you're meaning. And I do that. You guys don't have to do that. I do it because I think it saves the client money, rather than me having to go to the courthouse and us arguing in front of the judge and have the judge involved about what the request means. And then the other says, well, fine, I'll just serve another request and I'll reword it to get what I want. That just generates more fees, and it doesn't really help your client get the information they need, or the other side get the information they need, so that the case can move forward. So when you respond to requests for production, like I said, I was going to get to it. There are different ways to do that. So first, production must be kept in the usual course of business, or must be organized and label them to correspond with the category. So one way in practice I do, if you have Adobe Professional, is I do Bates labeling. So I get the records from the client. I organize them by what category of documents, or I'll even organize them by the requests that I got. Request for production, bank records, request for production 1 dash bank records, request for production 2 medical records, whatever it may be. And then after it's all said and done, and I moved out the privileged documents because I'm not producing those, I Bates label them by the party name or their initials. So in one case, I got production JSG, John St. Germain was his name, and then dash, and then the Bates number 00000-1, and then it goes on. When you go to respond, you can either say, and some people do this, and I don't like you when you do it. See documents attached. Well, great. You produced 10,000 documents. Where do I begin? What documents go to are responsive to request for production 1? Good luck. Good luck. And that's usually the people who do that. It is, here's some papers. Good luck. Figure it out. I work the other way, because not only does it hurt, it doesn't really move the case along to hide stuff and make work up the fees, but I want to know what is responsive to each request so that when I go to supplement, I can actually go and look at request number 1 and be like, okay, these are the documents that are responsive to that. Is there anything else? So I state the Bates range. I say see documents Bates labeled as blank, JSG0001 through JSG0010, for example. I prefer that. Now, it's costly. It does take time. You have to Bates label it. Then you have to go back to your request and you actually have to insert the Bates range, and it has to be organized in such a way that you're able to readily identify what's responsive to each request. But I think if you do it right the first time, then when it comes to trial, the other side can also say, well, they're hiding stuff. They haven't given me all the documents to request for production number 2. You can actually check yourself. You can go and look in your file and be like, no, and look at the request and say, no, I produced these, and check your file, check with your client and be like, no, that's everything. And you're in a better place. I also recommend electronic production if you can do it versus USB or CD via US mail, or the typical, this goes with the same people who say see documents attached. If they don't do that, they also say counsel can come inspect the records at a mutual agreed time. Okay, great. We didn't get any documents. We got this paper with the objections, and they say they're going to give us some records. Well, I don't have them. I actually saw someone sanctioned on YouTube a couple weeks ago for using that terminology in the probate court. So I wouldn't do it. I just use it. I do drop docs or share file myself, or USB, or if I have to do USB or CD because there's some technological defect, like I'm not able to get it. There's just too many files go on share file or Dropbox. I try to get it priority or get it there sooner, and I let them know. I prefer to do it that way just because it looks better to the court too, that you're not playing games. I gave them the records when it was due. I didn't make them wait. In this day and age, when someone's sending something by US mail, it's like, really? Especially, I had an attorney the other day send a paper packet production. They didn't even send it electronically. So I had to scan the scans. So I got the papers and then I had to scan them in, and then it becomes illegible. So, there's ways of doing it, and I know the Fort Bend Library has the resources. If you don't have the technology, they have scanners and copiers there. I've used them during trial for different things. So they have the ability to do that, and I think you can bring your own USB, scan it there, bring your own USB, and put it on your USB to get it produced. And if you have to have somebody take it over, do that as well. I also include in my materials a motion for protection. This is very, very important for people who are sent discovery requests that it's just so outrageous, or the person isn't complying with the rules or things like that. The timing of the motion for protection is usually, latest deadline is when the responses are due. As a practice note, how I do it is as soon as possible. You don't want to be in a time crunch having to ask for protection and like scrambling to do it, because it comes back to that whole thing where you're playing discovery games, and you're filing a motion for protection at the latest possible moment. You don't have it set, and then the other side tries to get, especially nowadays where you can't get a hearing for 2 or 3 months. So the case is sitting there for 2 or 3 months, and the person can't go forward with discovery. So if you think that you need a motion for protection, do it sooner rather than later. It also just looks better with the court. It's like, I got these discovery requests, took me a couple weeks to get through them, but I filed a motion for protection. And so my sample in the materials is a 47C motion for protection. So under Texas Rules of Civil Procedure, the plaintiff particularly, who's asking for the relief, has to include a specific request for relief or claim, and there's specific verbiage that has to be used. Well, if they don't comply with that rule, it specifically says in the rule itself, they cannot conduct discovery until they comply with it. So that's another thing you do. You get your discovery, and you look at your level plans, and you also look at their request for relief, and you look and like, do they comply with 47C? Stop right there. Need to do a motion for protection and special exception. They need to amend their petition to they need to comply with 47C. Now, instead of doing the motion for protection from a professional standpoint and under the rules, you have to confer. So you can call opposing counsel and be like, hey, I got your discovery and I was looking at your petition and I don't see your request for relief or it doesn't comply with 47C. So just giving you a heads up, you can amend it. We can do a Rule 11, you can amend it, and we'll wait on this discovery and we'll just wait until you comply, and then it's 30 days from when you comply. You make your amendment and comply with 47C, or I can file a motion for protection. And there's only one case that actually looks at that issue, 47C, the person not being able to conduct discovery, and it's a Tyler case. I don't know if I included in my materials, but there's only one case that's actually looked at that rule and you're not being able to do discovery if you comply with that. So the reason I say confer is because the judge is going to be like, really, come on, can't you guys talk, and can't you work something out? Can't you fix your petition? Another reason for protection I've included in the materials is tax returns, like I said, or net worth. So if somebody tries to do discovery regarding net worth, it's usually premature until they show they're entitled to exemplary damages. So if they're doing it for exemplary damages, there's a statutory mechanism and way to be able to even get to the net worth. So if they're starting and asking for net worth, tax returns, the businesses, financial statements and summaries, quarterly statements, like straight from the get-go, nope, motion for protection, premature. I've included a chart of privileges in the materials, and I've covered the different rules. And so just looking at time to make sure I'm cutting it close. You do not object to a request based on privilege, you assert it. And there are some exemptions under the rules, attorney-client privilege, a certain work product, that when it's exempt, you don't even have to assert it, the privilege, and it doesn't have to be included in the privilege log. I've also included a site to the snapback. So we're all human, and sometimes we have other people help us. Sometimes a document mistakenly gets produced. If that happens, so I'm the person that I always review everything that goes out, even if my paralegal produces, especially when it comes to discovery, because mistakes happen and I don't want anything privileged going out. But sometimes it happens. It happened at my last office, and it's done so quickly. Partner wasn't able to review it. Then he reviewed it after the fact. If you don't have time to review it the day it's going out, review it within a few days of it. You should, practice point, you should, but if you can't, do it within a few days, because if something is inadvertently produced that is privileged, you have a short window to snap it back. Very short window. And the problem with the snapback is it's great, like you snap it back, but the other side's already looked at it because you have to identify what it is, and they can't use the document itself, but they're going to have the information in the document. They're going to have read it, and they might even ask about some of the factual circumstances. Say it's a memo from a company, they'll be able to ask about it in depositions and things. So when producing documents, you got to be really careful, which goes back to that whole thing. Ask for the documents at the beginning of the case so you have more time to review the documents. And you can also, when you get the documents early on, you can tell the client, like, this isn't everything. I got your bank statements for this count for July through December, whereas January through June. I put my privileged documents in a folder when I'm going through the documents, if I do it electronically or paper. If I'm doing paper, I put all the privileged documents to the side and I have them scanned in and put into a privilege folder. If I'm doing it electronically, I extract them from the PDF and put them in a privilege folder, because I don't want to inadvertently produce a privileged document. And I have a list in my chart of all the different privileges that you can assert. And if you have it in that folder and the other side asks for a privilege log, you're already started, you already have your stuff organized in a way that you can do a privilege log pretty quickly. Versus if you didn't pull the privilege documents, you're just asserting the privilege and they send you the privilege log. You got a short window to look through those documents and do your privilege log. So I try to do it so that I'm not under that tight deadline where I'm scrambling to figure out what it is. You can, some people even do a privilege log preemptively before it's request. I'm not one of those people. I did do it because one of the partners I worked under preferred that, but I don't do it now just because I'm so busy and I use the folder method. Does anybody have any questions? I'm going to exit out.
So I got one question here in the chat for you. And let me find it. So when is an unsworn declaration allowed and instead of a verification?
Okay, so I can actually answer that. So even before COVID, it was allowed. So I'm going to actually, there's a Texas rules, so I have to pull it up because I don't have it memorized. I'm pulling up the statute so I can actually give you the statute. Okay, Texas Civil Practices and Remedies Code 132.001. An unsworn declaration may be used in lieu of a written sworn declaration or verification. So as long as you comply with the form that's under Texas Civil Practices and Remedies Code 132.001, the unsworn declaration can be used. There is an exception where it can't be used, and it's under that statute I just gave. For example, it doesn't apply to a lien required to be filed with a county clerk regarding real property. But otherwise, you can use it, and it's been that way for years. But because of COVID, I actually started using it because of the Texas Supreme Court order saying that we weren't allowed to have people come in person, do things. I started doing it on my deposition on written questions. I started including the unsworn declaration because there were people working remotely everywhere. And I didn't want to be in that circumstance that they're not able to get me my deposition on written questions because there's a notary stamp that has to be done, sworn acknowledgement or whatever. But it's just a way to get your records quicker and you don't have to go before a notary. So.
Okay, we got another question here. So we got a question from Jonathan, you have something to say?
No, I was just looking at Mr. Forlano's kind of question statement. You know, he's talking about, he says, my understanding on a case filed after January 1st, 2021, requests for disclosures do not apply. You know, that if the other side sends a request for disclosure, you know, should the reply be not applicable, and then no response, you know, beyond that, is kind of his question.
So if it was a case filed on or after January 1st, 2021, and they sent a request for disclosure, I'm guessing the attorney didn't do it. It was probably a staff member. It was probably a mistake. Just, you know, they sent them out. Or it might even be in the draft petition that they did. I bet it was just a mistake. I wouldn't even respond with a formal response. I would send them a letter and let them know and give an excerpt from the PDF I gave. The rules have changed. This case was filed on this date. This is premature. Requests for disclosures don't apply to this case. Initial required disclosures aren't due yet. And as far as the initial required disclosures, nothing has to be served for that. It is a requirement, like the federal rules. So if you're a plaintiff or a defendant in a case, and there's some exceptions under the rules, certain cases, I think I'd have to look. I think there's some family cases that are in the certain courts, like CPS cases and things that are exempt from that. And it lists it. I have it in my chart, the certain cases that are exempt from the required initial disclosures, but it's automatic. Their party in the proceeding, they have to serve required initial disclosures. Nothing has to be served by either side for that to happen. They have to, those are due 30 days after the answer is due. And so if
Yes.
somebody's added later, so if you say you join somebody later, another defendant, say I'm serving, I find out the employer, I need to sue the employer of the driver that I sued, then I have to join them. Their required disclosures aren't due until 30 days after their answer, if that helps.
It
We can,
does. Thank you.
You don't practice in family law, so I don't expect you to answer the question. I know one issue. I'm gonna go back and look and see those exemptions. Like we've started providing people with disclosure forms kind of when we give them divorce materials and stuff. But a lot of times, divorces are agreed, between the two parties. Maybe it's just a couple with no kids and whatnot. And sometimes we're like, do we have to do these? And I haven't really been able to give them a good answer yet, but it reminds me to go look and see if they're exempt in any way. My thought was that, if no one's complaining about the lack of initial disclosures made, does it matter, I guess, in certain cases like that.
So no. So I have it. I just had to pull up my chart because I have it in my chart. Okay. Yeah. So the family code. So it's an action under the family code filed by or against the Title 7D agency in Title D cases. So that's a specific subset. So if you're looking at just a divorce case, no, it does apply. Initial disclosures are required. A child protection action, a protective order action, which is like a family violence thing. That's what like I said, that's why that's a thing you can object if you're disclosing someone. Other actions involving domestic violence and an action on appeal from the justice court proceedings, and then a forfeiture action arising from a state statute, a petition for habeas corpus. So they're carved out. And so I've included in that my chart of the things that are excluded. But if it's like a general civil case, a breach of contract, a car wreck, a divorce, a probate proceeding, not necessarily a probate proceeding as in like a will, but if you're like dealing with a contest or an ancillary, then that applies. 47C, text rule of 47C, I should add this. The requirement for the request for claim, that rule does not apply to probate proceedings like will, where you're trying to get wills admitted, or guardianships. They do not apply. And that isn't under the Texas rules of civil procedure that says they don't apply. It's under the Texas Estates Code. Yeah.
Well, I just want to say, if there's other questions, go right ahead. But I wanted to say definitely before we end this, that one, this is an excellent course. The materials you provided, you're very generous in providing just a lot of good stuff for people. This is a lot of good hints and reminders and, landmines to think about and so forth. And, a lot of this discovery, it's all the devil's in the details. And you've given us some good thoughts on dealing with those details. So definitely appreciated.
Well, I appreciate everybody having me.
So ditto to what he said. I do have one more question. So when required initial disclosures, if they're totally inadequate, is the only recourse a request for production, or is there something else?
You can compel them. You can compel them. So with and that's how it would be also with, that's how you do it with the federal court too, which is what we're trying to mirror, is if somebody gives inadequate responses in discovery, you compel. You just compel. Confer before you compel. Once again, you need that certificate of conference, and you better confer before you go to the court, because the judge will be really frustrated if you show up without calling or emailing or writing a letter to the opposing parties.